I'd love to have our panel introduce themselves. As part of our hub, we have 6 professionals here who work together every day to help families move through the divorce outside of the courtroom in a way that preserves both their legal rights and their emotional well-being. And I will start first and pass the baton around until we've all had a chance to say hello. My name is Jolie Vacchi, and I am the founding attorney of Foundations Family Law and Mediation Center. We're based in Worcester, Massachusetts. Our philosophy is to resolve family law conflicts as painlessly and peacefully as possible, and we work throughout the state of Massachusetts. I'm a licensed attorney in Massachusetts and Rhode Island. I'm also a mediator, a collaboratively trained attorney, and a certified coercive control trauma informed attorney. I very much believe that education is empowerment, especially when it comes to the divorce process. When you know what your options are, you feel less stuck and you arm yourself with the information and support you need to make decisions to help you move forward. And that's why I love partnering with Vesta. I've been with them for over 2 years now, and I'm in 2 different hubs because they offer that through their educational programming, like tonight's webinar, and through that complimentary concierge service that I was just talking about to help you create your own divorce dream team tailored to your specific needs. So I'm very honored to be here with you tonight to hopefully help you clear some of the fog about what may potentially lie ahead for you. And with that, I will pass it to Lisa.
Hi, I'm Lisa Cat. I'm a divorce coach and coercive control recovery coach, and we're all so happy to have you here tonight. We know it's summer, your kids are home, you had to rush home from work. If you're in our part of the country, it was super crazy hot today. So thank you all for taking the time to hop on and hit play and joining us. I work internationally with clients all over the world and specialize in mostly coercive control cases in high complex divorce with high conflict partners. And divorce is a little different in every state, even in the same state, sometimes depending on which judge you have in every country. But I always say a jerk is a jerk, so we can build you a strategy wherever you live. They work a little different than most coaches. I work on helping people get ready for the business side of their divorce, getting everything organized, building their team of people like everyone we have here tonight. Then I also work on the really human side, the emotional side, the nervous system regulation. So you can come in clear. You can come in feeling confident and ready to make decisions that are going to affect the rest of your life. Then I also work in the section where it's post-divorce, because what I started to find was a lot of the people I'm working with, we would work together daily throughout their divorce. And a lot of times I found towards the end of their divorce, they were almost like a fish out of water. They had become coming out of these relationships that were oftentimes abusive. They go through the court system. It's no fun at all. I'm sure everyone here is realizing that. And then the divorce is over, and they're now what? My life for the past however many years has been surviving this unhealthy partner, getting through my day to day, and not getting through the divorce. So we start to work on building your new life from day one. What do you love that you haven't been able to do forever? What have you always wanted to do? Who are you now? Maybe you've been divorced for, maybe you've been married for 30 years. So you get to meet yourself again and just plan the next part of your life. So I work in a very holistic way, considering all of those factors, and then I also bringing in people like Tom, like Marty, like Jolie, like Maggie. So you're making sure you're getting the best, most expert professional advice for every part of your divorce, because that also keeps your nervous system regulated. When you have the knowledge, it's power. When you have all the right people on your side that are all fighting for you and for the best outcome for you, it makes a huge difference.
Great. How about you, Tom? You're up next.
Hey everyone, Tom Kilgallen. I'm a CDFA and a certified financial planner. I've been a certified financial planner for about 14 years now. I'm helping people move on to the next stage of their life, be it exiting a business, exiting a career, or exiting a marriage. I divorced 2 years ago. I got separated myself. I'm glad to say I made it through mediation relatively unscathed. It's not for everyone, but a lot of people on here it will be a fit, and I'm a big advocate of it where possible. So 2 years ago, I had no idea, despite being a certified financial planner for 12 years at that point, I had no idea how finances got divvied up in divorce, what the rules, what the guardrails were around that. Got my CDFA, got really stuck into that, wrote my book, The Divorce Financial Handbook, which is on Amazon. I'll send a link to that as well. And then just really just love working with these professionals here. I get involved in mediation either as a solo representative or as a financial neutral in mediation. I'm also trained in collaborative divorce, which you'll hear some of the panelists here talk about as well today, which is one form of mediation. And just we go back and forth with these professionals. It takes a village sometimes to really get someone through divorce. And that's why these professionals here are so valuable to me and the clients that I work with. I'm looking forward to tonight's discussion. I'll put my contact details in the chat. I do free 30-minute sessions with anyone that's interested, so do take advantage of that if possible. Thank you. I'll pass it on to, is it Maggie? Okay.
Thanks, Tom. Hi, everybody. I'm Maggie Egg. I'm a certified divorce lending professional with Divorce Mortgage Planning of New England and can actually help anyone nationally as well. We're based out of New England. Happy to help any of you nationwide. And as a certified divorce lending professional, CDLP, you'll hear that a lot. We help you look at your options for on the lending side. So sometimes that's refinancing the home, looking at options for the buyout of the marital home, looking at your options for buying a new place for this next chapter. But I really love being part of the staying out of court process and helping people come up with those solutions before, as you're putting together that separation agreement, really helping both people come up with a plan that you're successful after post-divorce. So like how Lisa was talking about all that after, we want you to be happy ongoing, right? And that's the goal of this team, on this group of people, and what Vesta in general is, just being a resource for you and coming up with solutions for you to make it the most painless process, because it is a lot to go through a divorce. And so if we can come up and crunch those numbers together, I'm a big fan of doing the math so that you can make the emotional decisions. I've been in banking for over 25 years and helped a lot of people navigate this, and I'm happy to be a resource for you. I'm going to put in the chat my contact information. Feel free to reach out and set up a free consultation anytime, and happy to be a part of this any way I can. And I will pass it over to Marty.
Thanks, Maggie. So, hi, everyone. I am Marty Chadwick-Balcom. I am an attorney and a divorce mediator with over 27 years of experience in family law. So, after many years as a divorce litigator, I now have chosen to focus my practice exclusively on mediation, helping individuals and couples navigate divorce in a much more thoughtful, efficient, and less adversarial way. So I'm based in the greater Newburyport, Massachusetts area, and I do work with clients anywhere throughout the state of Massachusetts. I work with folks both virtually and in person. I'm also someone who's been through divorce myself, so I understand not just the legal complexities of it, but the emotional and very human side of this process. I was divorced 18 years ago, and I can say that I'm also happily remarried, so I understand it from all aspects. What makes my work a little bit different is that I center nervous system regulation in everything I do. I know Lisa talked a little bit about that, and we'll continue to bring this theme throughout our presentation tonight. In my experience, most decisions made during divorce aren't just legal, they're physiological. So when people are overwhelmed or in a stress response, it is so much harder to think clearly, communicate effectively, and to make sustainable agreements, which is so important when you're getting a divorce. So my job is to help clients stay grounded and regulated so that they can make the best decisions possible that truly support themselves and their family as they move through the next chapter. So I do believe that the right information and the right support, you can move through divorce with more clarity, more control, and far less unnecessary conflict. So that's why I chose to work with Vesta. I've been part of this group since last October, and providing the education and access to the resources to help you make the most informed and empowered choice for yourself and for your family. I'm also the host of The Regulated Lawyer, which is a podcast that talks about nervous system regulation and the law, which the first episode just dropped on Monday. So I'm very excited about that. I'm so glad to be with you tonight. And we're going to talk all about mediation and other ways to get divorced that are not litigation focused. And I'm also a new puppy mama, and she is right here at my feet. So I'm looking down. She's probably biting my toes, testing my nervous system a little bit here tonight. So thank you for bearing with me. And I am going to pass it over to David.
Thank you, Marty. My name's David Meyer. I'm a certified divorce real estate expert and a realtor. And what that designation is, it's still fairly new across the country, but on top of regular role as a realtor, I've been specifically trained in handling divorce cases, both high conflict and ones that are working collaboratively. And I also have a background in law enforcement. I was a police officer for 12 years before getting into this field. And one of the things that can absolutely make or break a sale is that your representation is level-headed throughout the process. And especially in a case where everyone is working together, we want to keep it that way, because a regular sale can get things worked up a little bit, and there can be few more moving pieces involved in any type of divorce sale. So we have specific training that we use to keep things running smoothly, and knowing when to tag in everyone else in the process, because a lot of the times I don't get involved until the house is absolutely necessary to sell. That's where we defer to Maggie and Tom to make sure that that it is practical to keep it. And then if we decide that the house does need to sell, that's when the strategy comes in on marketing and making it sold, and keeping your privacy in mind too. One thing that's overlooked by a lot of professionals in the real estate industry: getting divorced is a change of familial status, and that's a protected class. So that it should not be disclosed at all unless it's going to absolutely interfere with some part of the process. So we keep everything confidential and make sure things are moving smoothly. I'll have my information in the chat as well. If you're not in Mass or New Hampshire, there are CDREs across the country. I can get you in touch with someone anywhere if you have questions on that topic as well. Back to you, Julie.
Thank you, David. So now that you all know a little bit about us, we are going to start the formal part of our presentation with our coach, Lisa Happ, to get us in a good frame of mind to receive all of this information that we have for you tonight. So take it away, Lisa.
Thank you, Jolie. And hello again, everyone. We always like to start our presentations with a little nervous system work, with a little grounding. Because like we said before, you guys have had a long day. You're going through a divorce. You're working. It's summer. You have kids home. So just giving you a little space to settle in from your day before you transition fully here with us tonight. We're going to talk about a lot of different things, a lot of different options tonight, because the fear sometimes of going to court, of litigating, of the things on TV, which are not true, by the way. Like when you're watching TV and you're seeing court cases, there's a good chance this is not going to be you, and most of it's not that accurate anyway. But when you hear divorce, sometimes that's the first thing our nervous system feels. And usually, often, if we're coming into a divorce, our nervous system is probably already dysregulated because we are in a relationship, we are living in a home where things are not going well. Your nervous system is going to go through fight, flight, freeze, sometimes even the fawn state. And it's going to run through all of them, and you're going to go through grief and all these confusing feelings and all of these thoughts. So whether you're here tonight because you're considering divorce, maybe you're going through a divorce, maybe you're supporting somebody else who's going through a divorce, we just want to start you off with a little minute for you to just sit, to be, and allow your nervous system to come down and allow yourself to exhale. So I'm going to remind you, everybody's cameras are off, so we cannot see you. So you can take this minute if you feel called to, and just close your eyes. Let your eyes get heavy. Let your body just start to ground and sit into the chair, or the floor, wherever you're sitting, and just feel your body sink into this space that you're in. And just start to allow yourself to go into some nice deep inhale and nice deep exhales. Just filling the breath up as much as feels comfortable to you. Then just releasing that and letting it all go. Starting to notice what you notice as you're coming into this space and coming into yourself a little bit tonight. Maybe you're feeling your shoulders softening. Maybe that buzzy feeling that's been in your head all day is starting to quiet down. Whatever you're noticing, just allow yourself to be, allow yourself to notice it. And maybe you let yourself really feel your feet on the floor, maybe even noticing that you have feet attached to your body. Maybe you notice yourself sinking deeper into your chair, noticing the sounds in the room that you may hear other than my voice, maybe sounds outside your home. Maybe noticing if you feel warm or if you feel cold or just feel like you're the perfect temperature. Just being really in this space, in this time, allowing yourself this moment to be present with yourself. Maybe we notice in your body as we're sitting here and breathing, if you feel any tightness, any tension. Like I said, it could be like a buzzy feeling. Sometimes people even feel nothing and they feel numb, and that's absolutely a feeling too. So, whatever you're feeling, just allow yourself to feel it. Allow yourself to lean into it and allow yourself to just sit there with that feeling and with that sensation. Often we want to push these feelings, we want to push these sensations away. We don't often give them a lot of time or a lot of space to be seen or felt or heard. So, just allowing yourself to allow it to be there. Allow yourself to lean into that sensation and maybe even allow yourself to lean into it a little bit more, almost surrender to it. As we're sitting here and as we're surrendering to it, notice what your body is doing. Is it allowing you to feel it? Is it allowing it to come in? Is it pushing it away? And there's no right or wrong answer. Just allow it to happen. And as we're sitting here and as we're feeling this and letting it do what it's going to do and just giving it a little bit of space, let's let your nervous system go into a really safe breath. So it's signaling to your nervous system that it is okay. It is safe to feel this. It's safe to be here right now. So to do that, we begin to inhale for a count of 5. Then we hold that breath in for a count of 2 if that feels okay. And then we allow it to exhale out for a count of 8. And now continue to just allow yourself to go into those 5 to 8 breaths. And just continuing there, going at your own pace, staying with that breath. Signaling to your nervous system that in this moment you are okay. In this moment you're safe. You're enough. You're present and you're taking this time out of your day, out of your week for you. Let's stay with those breaths for maybe just another minute, allowing yourself to feel what's happening inside your body, what you're sensing, and just stay with those breaths for a little bit longer. Just noticing whatever you notice. Maybe you're getting some messages from yourself. Maybe you're getting some answers to some questions that you were wondering about. Just allow it to be there. We're going to stay here for one more round of 5 to 8 breaths. Then when you're ready, we're slowly going to bring you back to the room so we can begin our official presentation tonight. So as you're coming back to the room, allow your breath to come back to a natural pattern for you. Start to notice your body in your seat again. Maybe you notice your feet on the floor. Slowly open your eyes so we're not shocking the nervous system awake. When you're ready, you can come back. You can open your eyes and join us. And just allow your nervous system a minute to come back to the here and the now.
Thank you, Lisa. So now Marty and I are going to talk about the legal landscape and the 3 different paths to settlement. And just a note before we dive in, Marty and I both are licensed in Massachusetts. And as I mentioned before, we are a Massachusetts based hub. So we are going to be operating from a Massachusetts framework. This is general educational information and should be valuable to all of our audience here today. But if you live in a different state, we do advise you to speak with someone who is licensed in your jurisdiction to get the details that are specific to your state, because divorce is state specific. Okay, so with that out of the way, let's start with the big picture. When you get divorced, there are really 4 true paths available to you. 3 of them keep you out of court, and 1 puts you in front of a judge. Tonight, we're focusing on the 3 alternatives to litigation, and then we're going to do a deep dive into mediation, which Marty will focus on. So let me walk you through each one at a high level. And as I do, I invite you to think about your own situation, your relationship with your spouse, the complexity of your finances, and whether you have children. And the right approach will depend on all of those unique factors. So the first way is negotiated settlement. And in a negotiated settlement, you and your spouse will each hire your own family law attorney. Those attorneys then communicate directly with one another through phone calls, emails, and letters. Your attorneys negotiate on your behalf, and the spouses themselves do not typically sit down together and do a lot of the negotiating on their own. We do that for you. This approach works well when the parties can't or shouldn't sit down together, when there's high conflict or safety concerns, or if there's a significant power imbalance in the relationship. One spouse might be much more knowledgeable about the finances or been more dominant in the relationship. In those situations, having an attorney who is advocating for you, who is not afraid to push back, can be really important. Also, a note here, if there's been if you have any concerns about a lack of transparency about finances, this also might be a good approach for you. The downside here is that this approach can be on the pricier side. Attorneys are charged by the hour. If negotiations are slow, the meter keeps running. And because you're not in the room, you will have less control over the dialogue and the process. The next path we're going to talk about is called collaborative law. Collaborative divorce is different. Both you and you each have an attorney commit to a structured process. You sign what is called a participation agreement, and it's a pledge that you will all try to reach a settlement without going to court. And so both spouses and both attorneys sign this agreement. In collaborative law, all 4 of you sit down together in what we call a 4-way meeting. Your attorneys are there, and often other professionals as well. A divorce coach, a financial specialist, a therapist, whoever is deemed you want on your team, whoever is specific to your unique circumstances. Everyone in that room is committed to this cooperation. Here's the key. If the collaboration process breaks down and someone decides to litigate, both attorneys must withdraw. That attorney can't represent you in court, and that is intentional. It creates a strong incentive for everyone to stay at the table and work it out. Because if not, then you basically have to start all over again. You have to find a new attorney and start at ground zero. Collaborative works really well for couples who want an intensive-based approach. If you have children and mental health or child development professionals present, that can be really powerful. However, it's more expensive than mediation because you have 2 attorneys in the room plus the specialists, and both parties have to genuinely want to cooperate. So it requires buy-in of both parties. And the third path is mediation. And mediation is what we're focusing on tonight. Here's the basic structure. You and your spouse hire one neutral person, a mediator, who does not represent either of you. The mediator does not decide outcomes. They are not a judge. The mediator also cannot give legal advice, so they're not your attorney. Instead, the mediator facilitates communications and agreements. The mediator helps you and your spouse communicate, understand each other's interests and positions, helps explore options together, and sometimes generate new options that neither of you may have thought of before, and help you reach your own agreements. You typically in this process do sit down in the same room together, or the same Zoom room if you're working virtually, with you and your spouse and the mediator. Both of you have a voice in this process. Both of you are heard. And outside the mediation room, you can and should work with your own consulting attorney who reviews everything, protects your rights, and make sure you understand the legal implications of any agreement. Because remember, the mediator can't give you legal advice. Mediation is generally the least expensive of the three approaches because you have one neutral, not two advocates. It's often the fastest because you are both in the same room problem solving together, and it gives you the most control. You are deciding the outcome of your divorce in the specific terms, not a judge, and that is extremely empowering. So, which one of these three processes is right for you? All three can work, but the right choice depends on your specific situation, your relationship with your spouse, and what kind of process feels sustainable for you. If you have a lot of conflict or safety concerns, or like we talked about, if there's a lack of transparency with finances, negotiated settlement or litigation might make the most sense. But if you are both committed to cooperation and want professional support, collaborative or mediation might be better. Cost, timeline, and outcome control vary throughout these three processes. Negotiated settlement can be mid to higher cost range, variable timeline. Collaborative is mid to high cost, a moderate timeline, with both spouses in the team involved in control. Mediation is typically low to mid cost, often the fastest, and puts the most control in your hands. All right, Marty, want to do a deep dive of mediation?
Thanks, Jolie. So, I want to talk about what mediation actually is because there's a lot of confusion out there. And I want to be really clear around what it is that I, as a mediator, do and don't do. So, first, we're going to talk about what mediation is. It is, as Jolie talked about, a structured conversation where a neutral third party, in this case, me, helps you and your spouse identify what you actually care about. So, what the issues are, understand each other's interests, which I like to frame as different than positions. We're typically coming in with positions, but if we really think about it as what's important to each of you and really listening to each other, helping and holding space for listening, and then together exploring what the options are to a resolution. So, as Jolie said, my job is to facilitate and to help you communicate, to help keep you both regulated enough to actually think and problem solve. So the key word here is neutral. So, as Jolie said, although I am an attorney and I have a lot of experience doing litigation, that's not my job here. I am not here to represent either of you. I can provide a lot of information, but I don't advocate and I never give advice. And I'm not telling either of you what to do, and I will never push for an outcome. I am truly here to hold space for both of you to honor the process and work together to find a solution that's best to fit your family. So, I also want to talk about what I don't do. As I said, I'm not going to give you legal advice. Although I am an attorney, mediation, that hat is off. I'm never going to tell you exactly, again, what your rights are. I'm going to talk about legal information. I'm not going to tell you whether or not the settlement is fair. It's absolutely the consulting attorney's job. So that's something that Jolie would talk to you about. I'm also not going to give financial advice. We're going to talk about finances, but number one, I certainly am never qualified to do that. So I will always bring in professionals like Maggie and Tom to really look at the issues around the mortgage and around a financial settlement. We can talk about how to split assets and what the tax implications are. But if we want a true analysis, we need to have a tax professional that's going to be part of that. So again, my job is a neutral to help you have these discussions in a safe and cooperative way and to be able to ultimately come to solutions. And knowing all of these amazing professionals that we're going to talk to help us get to that place. So the other piece that I really want to emphasize, and Jolie mentioned this already, is I don't decide. My job is not to be a decision maker. People try and persuade. They want to write to me to emails. They really want me to be on their side, but I'm not a decision maker. So I'm never going to actually pick one side over the other. I will listen to you and help you be able to express what you need to say so that the other person can listen to you guys together. So it's not going to be like, great, so you're going to have the house and that means you get the kids and here you go, here's your settlement. It's just not how it happens. This is a process that you guys are in it because you want to be holding the decision-making power. The other thing I want to talk about is that mediation, just like litigation, is not a one size fits all. So different mediators bring different training, different philosophies, different approaches, and even different backgrounds. So some mediators, like myself, were attorneys. There's also mediators who are therapists, and others have training in conflict resolution, negotiation, very varied backgrounds people are coming to the table with. Some mediators are laser focused and they are focused on getting you to agree. They're interested in the deal. Others, like myself, I'm more interested in the process. So, how do you move through this? Whether you feel heard, whether you're making decisions from a grounded place, or are you reacting in that place of survival with a dysregulated nervous system from either panic or fear? We do our mediations different styles. Some mediators do this back and forth, what we call caucusing or shuttle mediation, meeting with each of you separately and going back and forth. I do both. Some will only do joint sessions. Some are understanding and then we're trauma informed and nervous system informed, and some aren't. Some believe that divorce can preserve a co parenting relationship. Others are just more transactional focused. None of them are right or wrong. There is a mediator for every family, right? For every situation. But the fit, it absolutely matters. It's the same as when you're hiring any of us that are here on this panel tonight. You want to find the right person for your situation. So asking the right questions. How do you approach mediation? Do you have a nervous system awareness about you? And that's a new question, but more and more of us are becoming much more informed and understanding that we aren't just a legal case, that we're actually full humans with an emotional awareness and a component that is, we're bringing our whole selves to the mediation. And I think you're going to find that likely more in mediation than you do in litigation. There's not as much space for that question. I'd love it if we started asking judges, Jolie, are you nervous system informed? Not yet. Maybe we will get there. Asking them about, do you do pre-meetings? How do you handle conflict in the room? What's your philosophy around co-parenting? And as somebody who's doing the interviewing, really listening for the answers and trusting yourself. If it doesn't feel right, then keep looking. Interview more than one mediator. Same as with when you're looking at attorneys or any of the professionals that would go for that we're talking about. So I want to talk a little bit about mediation and transparency. Again, some mediators do extensive private sessions with each party. They're having one-on-one conversations where information is shared that's confidential to that person. I do my pre-mediation meetings and I do meet one-on-one with each person prior to our first joint session, but it's really a chance to understand that person's perspective and to try and build some trust and gain some understanding. It's really about me listening to them. But once we move into our joint sessions, it's all about transparency. So that means if something is really important, that if there's a concern or need, it's going to be talked about in front of both of you. Now, I may talk to each person individually to figure out how to bring that into the space. But this is really about a transparent communication. It's not about one person, again, trying to convince me because I have no power to make a decision. So we're not having these side conversations. Nobody's trying to manage how I show up. As the mediator, I'm going to try and really hold that space so that you both can show up as your best selves as much as possible. So as I said, I will have one-on-one sessions between the joint sessions if people are really stuck and we can't seem to get to resolution. And if I feel like they need a little bit more support, that's what I'm going to lean on. Someone like Lisa, if they don't have a divorce coach, or Jolie, really going back to their consulting attorney, they're advocating for them, they're answering their questions, and they're really helping them understand and stand up for themselves in the process. So that's why having a team is so important. So again, asking a question of the mediator as you're interviewing them, how do you handle communication? What is your policy around confidentiality? Do you ever have any one-on-one sessions where you wouldn't share something with the other person? These are all fair questions and things that you should be asking. So One of the things that I get asked a lot about is what if I have a really complex case? And mediation must be only for people who are really truly getting along and are not in these complex, either high conflict or really complex situations. That's okay. You don't have to be perfect. It is, mediation can still work again with the right mediator. So here's what I do as a mediator and my background, which I didn't share. I spent most of my years litigating, working in the field of domestic violence. So I have a lot of experience with coercive control, with imbalance of power, and really understanding safety risks. So that's part of the reason I have a pre meeting and I do a very extensive intake. And I'm trying to assess for safety and power dynamics before we ever sit down together and assess, is this case going to be right for mediation? And if I'm concerned, that I may structure the sessions differently. Again, they can be done maybe not with both people in the same room. I do it both, as I said, both virtually and in person. Maybe virtual is going to be better for a case where there's a lot of high conflict and someone's not feeling safe to be in that same space. Sometimes we do it in separate Zoom rooms, right? I'm in the middle, I'm talking, it's a virtual shuttling back and forth. And I've certainly done that in my office. I also will work with folks and their attorneys in the same room as well. So it's a little bit different than collaborative law because we're not signing that collaborative agreement that Jolie talked about, but the attorneys are there and we're actually all working together to help this couple get to resolution. So and again, people have had their coaches or therapists that you may want to bring into either the session or into your work. So it really depends on what you need and how your case is going to be done. So we'll talk about that. So this, again, it's not a one size fits all, and your circumstances very well may be okay for mediation, but you won't know until you talk to somebody about that. I want to just talk a little bit about the consulting attorney. I don't require it for many cases, and many people don't want to hire consulting attorneys. I strongly recommend it. And in some cases, I may require it depending on the complexity of the case. Because if we're talking about things that are really, when you sign a separation agreement, there are things that you're signing away potentially. And it's really important that both parties fully understand their rights. And again, even though I understand it, I can't advise people, and no mediator should be advising either of their clients. So it's really important that you're seeking outside legal counsel and working with an attorney who does this regularly and understands how mediation works and how to best support you. Someone like Jolie, who's trained in both, and it's absolutely amazing. So we want to make sure that you can have attorneys at any point throughout the process. Some people have them from the very beginning all the way to the end. Some people just hire the consulting attorneys at the end of the process to help them review the final agreement once people get there. So it's really up to your situation. So again, bringing in folks like Maggie and Tom and David are really important as well because they have independent, neutral advice around these issues around the house, around your finances, to help you make informed decisions. The goal of mediation is to make an informed decision that you can bring back and get into your agreement. That's the final piece. So the other piece that I want to mention is that my goal is to get everybody to a signed agreement and get them divorced, but that might not happen with every case. So just because you don't get a complete agreement doesn't mean that your mediation may not be successful. Many times mediation can solve 80% of the issues, but there might be one issue that's just not going to get resolved in mediation, in which case a lot of folks I have turn to the negotiating attorney piece. So they've got an agreement and they say, we're in agreement on these 6 things, but these last 1 or 2 things we're really stuck on, and we just can't get any further in mediation. So then we're going to really look to perhaps negotiated settlement, or last resort is to take that to litigation. But it doesn't mean that it's a failure at all. So I just want to be transparent about that. Okay. So that's a lot. I've spoken for a lot, and I really want to actually bring the rest of the team to back on screen so that we can have much more of a conversation around how we work together. Because I think one of the really important pieces of mediation that you don't get when you're in litigation is having this team-based approach to really help and support you throughout the process. So again, in my mediations, I typically work with all the folks around this table here. So we've talked enough about me. I am actually going to put it back to Jolie to talk about her role when she acts as the consulting attorney and share a little bit more about what that's like.
Thank you, Marty. All right. So when I am working as a consulting attorney, I am not in the mediation room. Sometimes my clients will hire me when they are engaged in the mediation process. And in that component, we are having meetings, regular meetings, usually to prep for the mediation. So a lot of times we will help them prepare their financial statement that they're going to be using in mediation to make sure that they have accurate numbers. And we're prepping a strategy for mediation, clarifying what their most important goals are, where they're willing to make compromises. I'm also helping them with negotiation strategy for when they're in the mediation session. And then when they're coming back from the mediation session, they can share with me what kind of proposals were made. We can evaluate those and I can give my feedback on whether I think that's a good compromise, a good offer, or if they agree to something that I think is a really crappy deal, then I can tell them why. And if I said, look, this is what the law is, this is what the statute is, if we were to argue this in family court, I think you'd end up with something a lot better for you. Then we can, in the next session, you can push back on this and let's make a plan for that. So that's how I work with clients if they're already engaged in mediation. If a client contacts me and they've already gone through the mediation process and they have a memorandum of understanding, which is a written document which reflects all the agreements that were reached in the mediation process, I can look at that and again tell them overall what my overall analysis and recommendations are, looking at the financial statements of the party. Sometimes, and I will say, not all of my clients are lucky enough to have mediated with a consummate professional such as Marty. Some of my clients come to me after mediation and they give me their memorandum of understanding. And I'm like, okay, can I see your financial statement and your spouse's financial statement? And they're like, what's that? They haven't even prepared financial statements. And I'm like, how were you able to reach these agreements if you don't know what the marital estate is that needs to be provided? So sometimes we need to backtrack and go back and recreate things and then adjust agreements accordingly from there. So I'm able to give my professional opinion on the overall agreement, see if any adjustments are necessary. If a separation agreement, which is also known as your divorce contract, which is what we submit to the court for approval, if you're going to file an uncontested divorce, if that hasn't been drafted, then I can draft that formal separation agreement for my client if that's something that they want me to do. And then sometimes if I just think that the agreement is so one-sided or awful, I can recommend, I think you need to go back to mediation and renegotiate some things because this is just unacceptable for these reasons, X, Y, and Z. And there have been instances where my client has been able to return to mediation, make some adjustments, and they've still been able to put through an uncontested divorce. But I've had other circumstances where the agreement was so one-sided and the other party wasn't willing to budge, and then we've ended up having to file. And eventually I have very few trials. So eventually we're usually able to negotiate a settlement after that, because then usually there's another attorney that's brought in and we're able to do that negotiated settlement process. But yeah, just to hone in on one thing Marty was saying, when you are signing a separation agreement and it is approved by the court in Massachusetts, the division of property, which is your assets and debts, it is essentially, once it's approved by the court, it's essentially permanent. It is extremely difficult to be able to change those terms. So when you sign off on that and it's approved by the court, if you're a Monday morning quarterback and you regret that decision, if you learn later on down the line that you got screwed, you are not able to go back and say to the court, I messed up, I want to change these terms. You can't do that. So that's why it is so important that you get that legal advice, like Marty was talking about, from a consulting attorney before you sign away your rights. So that's how I operate.
Awesome. Thank you, Jolie. So, Lisa, let's talk a little bit about how you as a coach help some folks in when they're in mediation.
So I work in a lot of different ways throughout mediation with my clients because mediation is so different everywhere. But often I'm coming in at the beginning when someone's really in that should I stay or should I go phase of divorce. So at first, the way I help is maybe helping them to arrive at the decision to mediate. Is it for them? Again, I exclusively work in the coercive control space. And so is it right with the type of partner that they are divorcing? And people always say to me, I can't mediate a narcissist, right? It's a huge myth. I actually highly disagree. Sometimes, yes, that is absolutely true based on so many reasons, and sometimes just based on where they are in the mediators that are available to them. But it also can be a very good move to mediate in these types of divorces and types of relationships because people with this type of personality, these high conflict personalities, love the stage. They love conflict. They love to fight and they love control. And they love to know that they're getting to you. They love to know that they're draining you and they absolutely know you and how to trigger you. So they will use the court system sometimes to keep dragging you back to court, to financially drain you, to emotionally drain you, to trigger you. And honestly, I think sometimes just to hear themselves talk because they love the fight, they love the drama. And then then sometimes a judge sees this. Sometimes your attorney can help a judge see this. Judges are human. You never know what they're going to see, what they're going to do, if they've had lunch that day, if they're cranky. We don't know. They're all factors. So once you're coming in front of a judge and you're disagreeing, and a lot of the choices about your children, your parenting time, sometimes your finances, you're leaving it up to a judge at that point who is hearing your ex's side, who is hearing your side, and they're deciding who's telling the truth. They're deciding who to believe, and you don't often have as much control. This is not, you cannot always mediate, but if you get, I often, depending on the case, sometimes it's a good place to start too. Just because you start mediation, if it all goes to hell and it's a giant mess, you can walk away and litigate. It doesn't mean that you have to say you're not cemented into mediation. I think we've all said it here again, but the biggest, if you're in a mediate, you have to find, and often I am finding the mediators for my clients, a mediator that is also an attorney, was there's one in the entire world. I work all over the world. There's one mediator in the entire world that I recommend to clients in my area that is not an attorney. Other than that, finding a mediator who is also an attorney is so key. Then also finding an that understands domestic violence, that understands coercive control, that understands the court system is huge. Because if not, what could narcissists, people with these types of personalities are very good at triangulating people. If somebody doesn't understand that type of personality, they may not be the best fit for you. But there are a lot of mediators out there. I highly recommend having your own attorney also, so you have somebody there that's there for you, that's there looking out for you, that's there looking for the most positive outcome of this divorce for you. Because even if a mediator can see through it, they can't say anything. They can't give you advice. They have to remain neutral. So you want somebody that has your back. I also go through a process with my clients, whether they're litigating or mediating, a little bit different than mediation, thinking about, okay, where do you want to be 6 months from now? And then where do you want to be a year from now and 5 years from now? So they have a little roadmap when they're starting to negotiate the mediation. They know what they want. What are you willing to let go of? What are your top 10 things that you're not willing to negotiate? What are you willing to let go of? And with me, when I'm working with my clients in the coercive control space, I like to learn a little their partner. And I profile them a little bit. And we figure out maybe what the partner wants, what the partner doesn't want, what their personality is, what makes them tick, what are their triggers. So I help them poker game in mediation. Sorry, Marty. Before they go into Dr. Marty or somebody, I create a strategy before you even go in. And then I often work with your attorney, talking about the strategy, understanding the legal aspects of your area with your attorney and how to create this strategy if you already have one. And with that strategy, then we role play often, which nobody ever wants to do because it feels weird, but then it ends up being fun. So we start role playing and I'll start pretending I'm the mediator. Maybe you're you at first and you're soon to be X at first, so that you're getting an experience of maybe some of the things that are going to go on, some of the things that are going to be talked about. I can't tell you exactly what they're going to say, but within reason. We're already going to know what triggers you and what you know triggers you from your ex or your soon to be ex. So I will throw all that in there when I'm pretending to be them. Because what happens in this scenario is your nervous system hears it, it feels it, and it responds to it. So it's not a shock to your system when you're in mediation. And your nervous system is already saying, oh, I know how this goes. I already heard this. And it was safe. It ended okay. So it's less triggering to you and your nervous system. I always strongly advocate to not be in the same room. I've actually never had a client because I have fought to make sure my clients are never in the same room as an abuser, as a toxic partner. So if they are on Zoom, there are different breakout rooms. I've been to many mediations where the mediators are running back and forth. We've had clients on different floors. We've had clients in different offices just to make sure my client is okay. They're mediated. They're not shutting down. Their nervous system isn't freezing because it is a lot, especially that's another thing. Marty doesn't do this, but there's some mediators that really like full day mediations. It's so hard for your nervous system. It does not make the process go any faster because you're so fried by the end. So if you have somebody that's really pushing for a full day mediation, I would probably not choose that mediator. It is so hard. It's exhausting. And sometimes by the end, you kind of just throw in the towel. You're exhausted. So that's a huge red flag. And like I said, if you're getting there, you're going through it and you just know you can't do it, like you're not getting anywhere, you can end mediation, you can go to litigation, you can take a break. If you're mediating and you need a break because you need to go walk around the building, you're feeling your nervous system, I'll remove my client. We'll go for a walk. We'll go get coffee and we'll come back. Because my goal when I'm working with people is to make sure they're taken. I am not neutral. I am just there for them, for their positive outcome on this divorce. And I want to make sure they're okay and taken care of the entire time. Throughout the process of their divorce, I'm also working with them on, okay, what is this guy saying to you or girl saying to you in this parenting app? Let's restructure it. Let's figure out how to take back control. Let's put you on the offensive instead of the defensive. Let's not fuel their need for supply. Let's create a strong boundary. Let's show them that they can't use their threats against you. These things that trigger you, let's work through these. Let's say it with your core wounds. Let's heal from this relationship. So when you are mediating, you're showing up very different than they knew you as in this relationship. So they're expecting you to do X, but you're doing Y because you're coming in empowered. You're coming in informed. You're coming in confident. You're coming in already knowing how to manipulate the manipulator in the most positive way. So it throws them off. So coming in with this mindset, sometimes you're coming in even from a much stronger place and a more powerful place than going through the court system and going through litigation because you have a lot more control of the space, the outcome, and the process. Like we're saying, is it a full day? Is it a half day? You can choose the mediator because typically when somebody is very toxic, water seeks its own level. They tend to find the meanest, nastiest attorney. And that doesn't mean they're a good attorney, but it means they're a huge pain in the butt and they hold up your case. And for some reason, a lot of times they seem to find criminal attorneys who are not family law attorneys who really hold up your case because they don't know what they're doing. So it doesn't feel like it if you're just thinking about it. But if you really break it down in mediation, you have a lot more control sometimes. And I will turn it.
Awesome. Yeah, thanks, Letha. All right. So, Tom, let's switch and we'll let you lead into the talk on the finances. So, how do you work with mediation as the financial advisor?
Yeah, so I'll break it into two parts. I'll talk first about when I act as a financial neutral for both parties in the divorce, and then I'll talk about solo representation, how that's a little different. I enjoy doing both. When I'm a financial neutral, a big part of my role is to make sure everyone's on the same page. A lot of times, I would say 80% of the time, you find that one person is the financial person in the household, the other person is not, and there's an imbalance there. So I'm very conscious and open to that imbalance. So it's first of all transparency. We're laying out in the software that I use all the assets, all the income. We're developing a budget as well, what that looks like pre and post divorce. And that's news to a lot of people that aren't party to these assets, knowing what the assets are, knowing what the spending is, where all the money is being spent on. Even the person that's the financial person in the household might not have a very good budget put together and be unsure of what they're spending on. So that's very helpful, number one. Number two, kind of level the playing field in terms of what are those assets worth after taxes. So different assets are taxed differently. 100,000 in a CD is not worth the same as 100,000 in a 401k, which will get hit with ordinary income taxes, or 100,000 in a Roth IRA, which should be tax-free generally. Understanding what those are worth. And then we get into looking at the child support guidelines, the alimony guidelines, what the state says. Here's what this might look like. Doesn't mean you have to agree to a particular child support or an alimony, but those are the guidelines that are in play that we look at as a starting point. And then we look at asset division scenarios. I can put side by side 3 or 4 different asset division scenarios. What does it look like if one person keeps the house and gives up some of the 401k or divvies things up differently? We look, is that an efficient way to do that? Is someone going to run into a liquidity issue if we break things up that way and divide things that way? Is it even feasible to do that? If someone wants to keep the house, are they going to be able to refinance the house, for example, to buy out the other partner? Can they afford to make those payments longer term? This is where it's really key to work with people like David, who's our CDRE, and Maggie, our certified divorce lending professional. I work together with these professionals to figure out what the real estate game plan is. And so putting that whole big picture together, I think when you have that transparency, lay everything out like that, it lowers the tension a little bit, which to me is a great goal if I can ease the tension and reduce the uncertainty. But a big part of what I like to do as well, ideally, is do a joint plan for the couple to show here's where you would be in terms of what you need for when you could retire, how much you could spend if you stayed together. Now, what does that look like individually? Do you have a sustainable plan? So for me, I think that's different from a lot of CDFAs. It's not just the transaction of divorce that I care about. It's what's your longer term plan, 5 years, 10 years, 20 years out, etc. And for me, if I can paint that picture for people, help them paint the picture, because I don't tell them this is the lifestyle you need to live. I'm like, to get to your goals as you've defined them for me, here are the different paths to doing that. Spend less, retire later, and then they come up with their own path through that. So that's as a neutral. Solo representation, a little more gamification, looking at the assets. One spouse might say, you're not touching my pension, or my pension isn't worth anything. Don't worry about that. I'll give you these assets instead. I'm just using the pension as an example. And that's where I come into play. Okay, are you really getting a good deal here? Or are they finding a way to screw you over or be a little clever with the division of assets, for example? And helping them think, if the other spouse had a CDFA, what would they be arguing for? What would they be looking for? And then some of those people in solo representation come to me before they even decide to get divorced to, number one, figure out, what's life going to look like for them if they get divorced? Are they going to be able to survive? How much will they need from a job? Do they need to get a job? The earlier they can work with me, the better on that. And then some people come to me in the final stages of their divorce too, to make sure they're not making a mistake. But that's interesting too. I enjoy that as well. This is a little bit of gamification there, as I said, and looking at, hey, if you value this a certain way. Some of it is art as well as science, the value in assets. Hey, can we make this argument that this asset should be valued this way or not, or whether this asset is separate property or marital property, etc. So that's a lot of what I do. I'm going to turn it over to David here. So David's a CDRE. He's going to explain to you better than I could why it's important not just to deal with any realtor, not like your sister's golf partner or your brother-in-law. What you want someone expert in this field, particularly in a mediation scenario. That's where people like David really come into play and show their worth and differentiate themselves from other realtors. So I'll let David talk a little bit about what he does.
Thanks, Tom. And that's one of the main reasons that this designation was created in the first place. Two of the biggest things that tend to be the argument with the household is who's going to be the realtor and what's going to be the price. And what's really important when you are talking about the sale of the house is that you have someone that's actually not going to just tell you what you want to hear to try to win your business. Because especially right now, in a lot of parts throughout the country, the market is declining, and a lot of folks are telling you, you'll get, yeah, that number sounds great. Let's get this going. And especially in these situations where it's going to be crucial on what those proceeds are going to be, you need to have something that's realistic and that's also going to work or be in compliance with whatever the agreement may be. And I've taken a few notes as we've been going along, as Jolie was saying, with the mediation agreement and that becoming final afterwards, the timing of when the home is sold, it can vary. I've seen some where they want to get it sold before they even start. I've seen others where everything's final and they have a time frame to get the house sold. And it can be just as important to maybe write in the realtor you want to work with, because a lot of contention can come up mid-sale. And an example I see pretty regularly is we are seeing a lot of inspections now. Massachusetts actually passed some new legislation where home inspections aren't required, but sellers and sellers agents cannot accept an offer that has waived inspections, and buyers are not allowed to submit an offer where they're waiving inspections. So it's pretty much to be expected that the buyer is going to conduct a home inspection on the house. And so just because we have it listed at a certain price and just because we are getting activity doesn't mean that all of a sudden, a couple weeks in, we're dealing with a concession request or something being required by the lender to be fixed. And this is where a disagreement can really throw things off track, because the way a realtor's representation works is I only work for the deeded parties as a fiduciary. And so depending on how the home is deeded, if both parties are on the deed, then I represent both parties. I do have some addendums that broaden the scope a little bit depending on the nature of the situation. If it's a contested divorce, it gives me permission to discuss things with counsel. And it also gives me permission to escalate things if needed to the court, because if a disagreement arises and the only thing hanging things up is they're asking for $20,000 after the inspection and one party wants to move forward and the other says no, we may lose the offer. And then that's why it's really important to make sure that these details are really thought out before the home even gets listed. Who's going to be the tiebreaker? Who's going to be the agent? What's our game plan if it does not get an offer in a few weeks? We are seeing things sitting for a longer period of time and then doing a price adjustment. Are you going to pre-bake that into things? So having this game plan in place before you get started is crucial, because many times both sides are required to make this move forward. Or it may even be a situation where there's a non-titled spouse that has a say in the home sale, if that's an agreement that's come up to. I need to make sure that all that's in writing on my end before I can even begin. So, but the timing of it is going to be the most important part. I'm not an attorney, so a lot of times there's going to be questions about how the proceeds going to be split, and my fallback is it's either how it's already been agreed to or whatever the mediation or your attorneys come out with. But part of our training is on a level of mediation as well, is we're keeping everyone separate throughout the process. There's no group text, no group emails. Everyone's getting updates in an equal manner. Going back to having the cousin realtor, everyone knows about 10 realtors, and usually 1 out of 2 people is more comfortable with them. We want to select someone that's not going to have any implied bias towards one side or the other. I don't play favorites. I try to treat the household as the main client, but again, it's legally, it's the deeded parties that are my clients. But you want someone in there that's not just trying to push things through to make a sale. I have a fully functioning regular business on the side of this, so there's no incentive for me to just push things along for the sake of the sale. And a lot of realtors do tend to fall into that trap where they're looking into just getting the next sale down. So typically Tom and Maggie, when they're in their planning phases, will reach out to me and I can perform a fair market valuation of the property. It is not an appraisal. It's an opinion of value similar to an appraisal, but it's based on a realtor's eyes versus an appraiser's eyes. And sometimes that can be sufficient for them to factor those numbers in to what they need to do to make things move along there. The other thing I like to make sure that is known ahead of time is where are the proceeds going to go and what is that division going to be? If it's not a 50-50 split, if it's being held back for something else, those are all things that you want to know before before the home goes on the market. So the timing is crucial. Making the decision of who's going to be the tiebreaker and things like that are very critical to kind of work through before it goes on the market. And then for the ones that the house has decided to be sold after everything's finalized, part of the guidance that I will give is if we do reach an impasse, hey, they're not cooperating with the agreement, that's when you need to get Jolie or Marty back involved to enforce it. But knowing when we can't move forward, though, because there are points that if we try to proceed and we don't have the green light to do so, it could jeopardize your sale and set you back. And I'll let Maggie jump in a little bit more with some of the financing side of things.
Thanks, David. And yeah, collaborating with David and Tom and all of my partners here tonight. It's just a great way to, again, like I said earlier, help you navigate this as painless as possible. And that's what I do love about mediation is if you're staying out of the courts, just trying to come up with some solutions that sometimes getting more creative, helping each other reach the goal. Something we hear about a lot as the mortgage professional. So I'm a mortgage loan officer and a certified divorce lending professional. And partnering up with my colleagues like Tom and David, and through the mediation process, like when Marty has her clients, you're bringing me in to talk about what can either you yourself, if I'm working for just you, or you and your spouse if I'm working for you as a neutral, what can you guys afford? So about 75 to 80% of divorces involve real estate, right? And so one of the biggest questions we get is, can I afford to keep the marital home? Whether that means you're going to buy the person out. There's some questions tonight about keeping the house in lieu of alimony, all these different things. And those are all the different ways to go about it is what can happen when you're staying in other courts. If you're leaving it to the judge to decide, it's going to be a little more like just, here's what you have to do. But in mediation and where we can get creative on different lending options and what one spouse can afford and the other, we can talk about child support and alimony and how is that going to affect one spouse qualifying, or how is that going to maybe impact them not qualifying, because if they're the one staying in the home but they're also the one paying support, it might be difficult to afford all that. I've been in banking, like I said, over 25 years and a mortgage loan officer for a long time and a certified divorce lending professional for over 3 years. And I love that expertise. There's probably about 200,000 mortgage loan officers in our country, and less than 1% of us are actually certified in divorce lending. It's definitely a focus of mine, and helping you through this and being creative and trying to set both of you up for success post-divorce is always my goal. Working with Tom, a lot of times I'll be looking at what does someone qualify for, right? And then I say to them, okay, on paper and with the numbers, yes, you qualify. If we went to an underwriter, they would approve you. But then there's also, how sustainable is that? Is that really in the long run what is good for you and your family? And so I'll oftentimes bring Tom in if he's not already involved in the situation and have him go through that budget that he does and go through all that software and looking at your long term. Okay, yes, on paper you'd be approved, but you're using 50% of your income to afford this mortgage. Does that really make sense to be doing that? And life's expensive, right? Kids are expensive. I've got 3 of them and oh my gosh, they're so expensive. But it's really about, yes, looking at the numbers, but it's not just transactional. It's not just go and get a pre-approval like you could at any mortgage loan officer. It's about really looking at your situation. Maybe it makes sense to, yes, buy out the spouse, but look at those other assets. Like Tom was talking about the retirement. And if we're doing something like that, we're going to make sure that we've looked at the tax consequences for using retirement money. And we're making sure you're taking out the right amount to offset that for the other person. There's a lot that is involved in divorce that's unique to divorce and dividing assets. And those of us here tonight really understand that, really understand the ins and outs, but also how to be creative and to work together. And especially when you're wanting to stay out of the courts, so that we can help you come up with a plan that ultimately a judge will sign off on. Because as Marty and Jolie mentioned, in the end, Marty is the mediator working with you, Jolie is a legal representation, but in the end, your agreement has to be signed off on. So we want to make sure we're coming up with a plan that can be signed off by a judge and executable after the divorce. So after the divorce, I would then be able to help you do a refinance or a new purchase of a home, whatever those things would be. So I'll help you through the process, figuring out the numbers, and then after to execute whatever plan we come up with. I believe I am turning this back to Jolie.
Marty, do you think we should transition into some questions now that we have
Yeah,
about minutes left?
I think that would be great. I think that's a good thing. So we've got some great questions. Let's see. Did we answer all the questions in the Q&A? I haven't popped it back.
Yes.
Great.
So,
Yeah, we have the
All right.
Yeah.
All right. Yeah. So let's take a look. I think there's a good question about, again, we're in Massachusetts, and I know that a lot of people here aren't in Massachusetts, but I think there's some that we can answer that are general questions. One is about if your spouse refuses to discuss what they need in the separation and refuses to respond to the settlement proposal provided. Again, this is probably in maybe negotiated settlement. I think if you're in mediation, part of the benefit of the mediation process is that you're in active conversation, right? Versus the negotiated settlement. Sometimes you've got what I think when Julie was talking about it, one side has an attorney and the other side doesn't. And I'm not sure if that's the situation in this case as well. I think that the downside for many of these out of court strategies are that there has to be a willingness of both parties. And if one party is unwilling to participate, it really goes back to litigation because the judge can ultimately hold people accountable in mediation, collaborative law, or even in the negotiated settlement, if a party's unwilling to be part of the process and respond, and it does happen, it absolutely happens, then I often let people know that you need to get back into the court in front of a judge, which can take time and it's very frustrating. I certainly understand that. Other thoughts on that, Jolie?
Yeah, I was just going to add that sometimes it does take filing a divorce in court and having the other party serve to motivate them to want to cooperate in the process. Sometimes it's like the formality of having a case filed inspires them to want to participate, and that can have a variety of factors. Maybe they really were hoping that a reconciliation was possible, and then that formal process really solidified that wasn't possible for them. So sometimes a formal filing can be helpful, and then you could return to mediation and see if either that or a negotiated settlement is possible after that point.
Yeah, I think one of the questions in the Q&A that we did answer was that around, do you have to file your agreement together or can you file first and then go to mediation? And the answer is both. Most people that work with me has usually come to me together and they're wanting to be in this process together. But certainly some people, for various reasons, just like Jolie said, end up filing. And then once the filing happens, the other parties, oh, I don't necessarily want to go through this litigation process. And while it's open in the court, you can still do mediation to ultimately get your agreement. As Jolie said before, most family court cases, at least in Massachusetts, don't go to trial. I've been in this work for however many years, I said, over 20 years, 27, I think. I've never done trial. I've been prepared for trial many times, but most of my cases, usually all the rest of them have settled. So it's something that there's a continuum to be able to land on there for sure. All right, let's see. What else have we got for questions? There's one here that asks if mediation is advisable when one person is a stay-at-home parent and the other is the main provider who's also been controlling the finances mostly. Yeah, mediation certainly a possibility. It's always a possibility. And I think that one thing I want you guys to take away from this is it could work for your case, and consulting with a mediator to really understand if your case can work is a great next first step. This might be a case, depending if I were doing a consult with you, is one where I might want to bring somebody in, Tom, whether to be able to level the playing field. One thing I do in all of my mediations is the first thing we do after we agree to engage in services is you sign a mediation services agreement. And I list out all the things that you're agreeing to do. And one of them is absolutely complete financial transparency. So we're not only going to do these financial statements, but we have what we call as Rule 410 disclosure, that you're each going to share all of these documents and be part of that. And then My job, again, is not going to be to walk you all through that and help you understand that. If that's something that you need, we're going to bring in someone like Tom to be able to help understand. But we have the information so that you can make the decisions. So mediation could certainly work in a case like this with the right setup and making sure that you're doing full financial disclosure and transparency.
As long as there's a commitment to transparency, it doesn't matter that much to us how big the imbalance is. One person can make $500,000 a year, the other person stay at home. The one person financially savvy, the other person not at all. We can work with that as long as we have that commitment to transparency.
Yeah, and I would just add that, again, you're going to want to ask these questions when you're interviewing mediators because not everybody has the same rule that Marty does. So not all mediators require this financial transparency and just rely upon the representations of the parties on. I mentioned earlier, some don't even require the parties to complete financial statements. So you're going to want to ask these questions when you're interviewing mediators.
Yeah. Another question, there was something about taxes. Where did that question go? What to do with the taxes when one partner does not have the will to do taxes? Does the marriage, when you're done with the marriage, separate taxes file, but no partner wants to do taxes? So, Tom, maybe you could just talk a little bit about kind of the taxes pre and post divorce, just a quick overview.
I was going to punt this to you guys, to Jolene, because if someone's not cooperative and not doing the right thing and not giving the right information, that's where you guys got the leverage there, especially on the legal side. I don't have a ton of leverage in that regard. I can have people figure out where someone's not being very transparent or obfuscating, but you will have cases where people are just not delivering or what they said they would or what they agreed to post-divorce, and they're not following through on their commitments in terms of doing this and that for taxes. So I'm going to punt a little bit to you guys on that question. Mine's, and you can
No,
kind of hammer you bring to play, or can.
Yeah. So I get this question a lot when divorce is pending in court. We have to file our taxes. We're still married. How should we file? And you have the option of either filing married, filing jointly, or married, filing separately. And so what I usually suggest is that you consult with your CPA and have both versions run to see what the outcome would be for you in both situations. Typically, when married parties file jointly, and again, I'm not a CPA and a tax expert, but it's my understanding that you get more of a tax benefit if you file jointly. So you'll either pay less in taxes because you'll have a bigger deduction, or you'll receive a higher refund back. And when parties are litigating their divorce, we're trying to keep more money in the family. Usually that's what we're trying to do because you're paying attorneys and professionals and we're trying to keep more money in the family. So if possible, the preferred is that we usually try to file married filing jointly. But sometimes that's not possible because the other party won't share the necessary documentation that's needed. Or we might have a concern that maybe the spouse might have some shady stuff going on and we don't want our client's name on that. So it's going to depend on the circumstances. So I usually I send them to the CPA, have them run it both ways, and then we discuss with the CPA's recommendations what it is. But if there's a divorce judgment and it says how everyone's supposed to do taxes post-divorce and the other party's not following through on those court orders, that could be a contempt action could be filed because those are valid court orders and it would be a violation of that. So that would be a separate issue.
And if you're doing mediation, again, I think that this is where sometimes having an attorney that's your mediator can be helpful because we know what has to be in the agreement. And we're going to make sure that there's certain things that are going to be in that agreement. And I've seen some agreements where taxes aren't even talked about. They're just not even mentioned. And then you don't really have recourse because it's never been addressed. Working with a professional who really understands what needs to be in that agreement and what you need to talk about and decide is very important when you do.
We do collaborate with, sorry, I was referencing where someone's uncooperative, but where people are collaborating, we work with their CPAs all the time, and we look at things like how best to deal with future capital gains, for example, and how to time that out. And don't forget, some tax losses can be an asset as well. We need to account for that sometimes as well. It's a real asset as well. But yeah, I was referencing more where people are uncooperative, where the lawyers kick in.
Yeah. And that might be a case that doesn't end in mediation. So it's always good. All right, 8 o'clock.
Yeah, there's just
Did we get in?
there's one final question in the Q&A I just want to wrap up on. And it says, why can't consulting attorneys stay on after if it gets to litigation? And the consulting attorney can stay on if you're engaged in mediation. It's only that collaborative divorce process where the attorney couldn't stay on if it ends up in litigation. That's the only one. But if you're a consulting attorney in mediation, you can stay on for litigation. So just to clarify that.
Yeah.
Yeah.
I know we're over time. There was one other question someone asked. Am I getting a good deal if I give up alimony for the house, etc.? That's where you need a CDFA to kick in to figure out the net present value of that alimony. What's that worth in terms of the equity in the house, etc.? People ask me questions like that all the time, but I'm thinking it's a little more complex. We need to do some calculations around that. I can't tell you right now what you're getting a great deal in.
No. All right. Thank you, everyone. It's been lovely to spend this time with you tonight. And we're grateful that you were here with us. And I'm sure you will be hearing from our concierge team tomorrow following up. And yeah, thanks for being here.
Thank you. Have a good night.
Good night, everybody.